Thank you for the invitation to participate in this project again after this very successful project 2 years ago. Sorry that I'm not able to join the whole conference today because I have some classes, but I will come back later again. As I agreed with the organizers, I want to give a short overview on the Austrian investigation in criminal matters. We'll show some current problems and will present some aspects of the use of evidence in criminal procedure. First of all, it is an important feature of the Austrian fraud prosecution system that there is a structural duality between expenditures and receipts of a state or of the EU, which also has consequences for the prosecution and for investigations in cases of offenses which affect the financial interests of the EU. Fraud which relates to state or EU expenditures is governed by the criminal code, and fraud related to receipts of a state or the EU is governed by the Act on Fiscal Offenses. What does this mean for investigations? Regarding expenditures, the investigations follow the provisions in the Code of Criminal Procedure. Regarding taxes and customs, in principle, also the Code of Criminal Procedure is applied. However, in the Act on Fiscal Offenses, specific provisions are provided for which differ in some aspects from the general provisions in the Code of Criminal Procedure. In fiscal penal law, the competence for leading the procedure, investigating, adjudicating, and sanctioning is divided between administrative authorities and criminal courts, depending on the amount of the evaded taxes. It is divided into an administrative fiscal penal procedure for minor cases and a judicial criminal procedure for major cases. A central role in investigations in fiscal penal cases is played by a specific authority, an administrative authority, the so-called fiscal offense prosecution authority. In minor cases where the damage of a tax evasion is not more than 100,000 euro, it is the task of this authority to investigate, prosecute, and adjudicate. In other cases, it's more complicated, and this authority plays a special role in criminal investigations. I will come back to this later. The main players in criminal investigations following the Code of Criminal Procedure are the Public Prosecution Office and the Criminal Police. The Public Prosecution Office is head of the investigation proceeding and decides about the continuation and the end of the investigations. Most of the investigative measures must be ordered by the public prosecutor and they are carried out by the police. Only in cases of investigative measures which interfere with fundamental rights of the accused or of a third person, for example, pretrial detention, house search, telephone tapping, the order of the public prosecutor needs to be approved by a judge. In reality, at the beginning of investigations, mostly the police investigates on its own and only in complicated and difficult cases, as, for example, economic criminal cases, the public prosecutors investigate on their own. In most cases, the police investigates the cases. there is a specialized central public prosecution service for the prosecution of economic crimes and corruption cases, which is seated in Vienna, but is competent for all for the whole territory of Austria. And it is competent for severe cases of economic and fiscal penal crimes, which with a damage of more than 5 million euro, and in cases of corruption. During the investigation, the court has only the competence to approve certain coercive measures, has to decide on applications for the imposition of a pretrial detention, but only in exceptional cases, like investigations against prominent politicians. Only in these cases, the investigations are led by the court itself. Finally, the court is competent to decide on remedies of concerned people who claim that they were violated in their personal rights by investigations by the public prosecution service, since they it was refused to exercise their personal rights, or the provisions of the Code of Criminal Procedure were violated. In tax and customs crimes, the investigations are not led by the police, but they are led by tax and customs investigations authorities. And I have already mentioned it. There is the Fiscal Offense Prosecution Authority, the Finanzstrafbehörde, which is competent for the clarification and prosecution in duty of the criminal prosecution. This authority has to perform the task and has got the powers of the criminal police and has to perform this task instead of the criminal police. It has to apply the provisions of the Code of Criminal Procedure, which is a standard basis for the investigation proceeding. Therefore, in principle, there are no specialized, no specific procedural rules for financial criminal investigations. However, there are some specific powers for the fiscal offense prosecution authorities, which are laid down in the Act on Fiscal Offenses, for example, inspections and examinations according to the tax and monopoly provisions, or the right to obtain information from providers of public telecommunication services. That's differently or different to the rules in the Code of Criminal Procedure. The Public Prosecution Service also conducts and supervises investigations in fiscal criminal offense cases. It was already mentioned that I want just mention one major problem of investigations in economic criminal cases in Austria, and this is the duration of investigations in economic criminal cases. Investigations in some big economic criminal cases last for more than 8 or 10 years. We now had a big corruption case where the facts took place in 2002. Investigations took more than 9 years, the main proceeding more than 3 years, and we still have no final decision nearly 20 years after the behavior was set. What are the reasons for that? The Austrian criminal procedure is characterized by the principle of material truth. This means the law enforcement agencies are obliged to investigate all details of a case, even if they are not relevant for the application of the criminal offense, or does only concern minor aspects of the case. This principle perfectly fits to common criminal offenses like theft or bodily injuries, but it's complicated in cases of economic criminal proceedings and results in very long and complicated investigations, since the facts are so complex and it is nearly impossible to investigate all problems. However, it is difficult under the current legal provisions to focus and limit investigations in certain, on certain and the most important facts. There are no possibilities of agreements in criminal procedure, at least no official possibilities. The Austrian Supreme Court said that judges commit an abuse of official authority to take part, if they take part in any agreements. Another reason is that in economic criminal proceedings, often a large quantity of documents and especially storage media with electronic data are freezed, and the criminal police or the public prosecution office have not checked the relevance of these documents and data for the proceeding due to the extent and the complexity of the proceeding. The freezing of these documents and storage media for evidence reasons is only justified by the necessity to check the content of these documents and data, and it takes many months, sometimes even years, to check the relevance of these documents or this data for the investigation and for the concrete case. Often specific expertise is required. It is necessary to appoint an expert, and this leads often to further delay, especially if the expert has not yet been involved in this proceeding and therefore does not know the case in detail. Let me come to the question of use of evidence in criminal proceedings. The Austrian legislation in principle enabled to use all evidence collected if there is no explicit prohibition to use the evidence. Such an explicit prohibition exists, for example, for certain investigative measures, for example, for telephone tapping or visual surveillance, but there are many investigative measures where we do not have such explicit prohibitions. If an evidence is illegally collected, this does not mean that all other evidence which has been found because of this evidence cannot be used. In fact, it must always be examined for every evidence, whether it is usable or unusable. If the law explicitly says that the collecting of a certain evidence or a certain investigation measure is void, this means that it cannot be used or is not allowed to be used in trial. However, in most of the cases, evidence can be used even if certain rules of evidence were violated. For example, if the rules for a house search were violated, the results of this house search can be used. The Supreme Court explicitly ruled that evidence can be used, and it said that these objects and data have not to be given back to the owner and that it is not necessary to destroy this evidence since this is not explicitly foreseen by law. A violation of prohibitions on the collection of evidence does not have automatically the consequence that the evidence may not be used in the main proceeding or in the investigation proceeding. However, the Supreme Court limited the use of such evidence insofar as it must not be taken into account as reason for the decision to commit the case to trial or for the arrest or pre-trial detention of the accused. This means the Supreme Court does not limit the use in general, but the possibilities to take them into account in investigation proceedings. Regarding the use of evidence gained in an administrative proceeding, there are no rules which prohibit the use of such evidence in criminal proceedings. Such evidence, for example, documents may be introduced into the trial, and it is up to the court to evaluate this evidence in free assessment of evidence. The rules for interrogations laid down in the Code of Criminal Procedure are not applied to interrogations by other authorities in administrative proceedings, and it is no problem to use the results of this interrogation in a criminal proceeding, even if the rules of the Code of Criminal Procedure have not been observed. For example, in administrative proceedings, it is not necessary to inform the concerned person about the right to remain silent if there is a risk of self-incrimination. Nevertheless, the results of this interrogation can be used in the criminal proceeding. Therefore, in general, it can be stated that the use of evidence gained in administrative proceedings is not excluded in criminal proceedings. However, in the doctrine, it is said there should be limits to take over evidence from tax and duty proceedings, for example, if they do not comply with the principles of criminal proceedings, especially with Article 6 of the European Convention on Human Rights. Regarding internal investigations, we have already heard a lot from Professor Sawyer this morning. Therefore, I just want to add shortly that there is no law in Austria which rules internal investigations, and there is also no law about the use of evidence collected in internal investigations. Therefore, in principle, it is allowed to use evidence which has been collected in such investigations. The use of such evidence does not make the trial unfair. It's the same reason why it is quite easy to use also evidence collected in other member states. The bigger problem is to get this evidence. That is not only a problem with countries outside of the EU, but also with other EU countries. Prosecutors often say it's easy if they can have a direct contact with prosecutors in other member states, but it becomes difficult if it is only on an official way. They use the European Judicial Network, they use Eurojust, but whether the contact with authorities of other member states is successful in many cases depends on the effort made by the individual investigator or prosecutor in the other member state. Let me come to an end and to a last point, because it's very current. 5 days ago, the law to implement the EPO regulation was passed by the Austrian parliament, quite late, but they did it. It provides that Austrian law concerning the tasks and function of public prosecution, of the public prosecution service, also applies to the EPO, as far as this is not in conflict with European law. The EPO is competent for the investigation, prosecution, and committing the case to trial in PIF cases, and has the same position as the Austrian Public Prosecution Service. According to Article 13 of the EPO regulation, the European delegated prosecutors shall have the same powers as national prosecutors in respect of investigations, prosecutions, and bringing cases to trial. It is ruled by this new Austrian law that the European delegated prosecutor has to proceed according to the provisions of the Code of Criminal Procedure. And in particular, he has to observe all conditions and requirements for investigations and taking of evidence. Let me come to a short conclusion. One of the main problems of investigations in economic criminal cases is the long-lasting investigation proceeding. It seems that the current legislation makes it difficult to speed up such proceedings, since all cases must be investigated into details. This takes a lot of time, takes a lot of requires a lot of patience for the accused and also for the authorities. The use of evidence is mostly admissible in Austria, since there are only a few explicit prohibitions to use evidence in Austria. Therefore, also evidence collected in administrative proceedings, in internal investigations and other states is possible in the most cases. The bigger problem seems to be how to receive evidence from other states. However, in PIF cases, this should and could be improved when the EPO takes over the investigations in these cases. Thank you for your attention.